The purpose of this hearing today is a subject matter hearing on a resolution before this body, Resolution 25213, call for a hearing regarding the Cook County Court System's operations and its impact on the city's annual budget appropriation and resources with regard to outstanding warrants and the enforcement thereof. It is presented to us by committee member Alderwoman Tabarez, and she will open.
Yes. Thank you, Mr. Chairman. I want to open with a statement and then lead into my questions. Good morning, everyone. I want to thank everyone who supported this resolution calling for the special hearing with the leaders of the Cook County Court System to discuss overall public safety and 3 critical focus areas: warrants, protective orders, and GPS monitoring programs. As the chair of the City of Chicago and Cook County Violence Against Women Task Force, I have been encouraged by the recent collaborative efforts between our governments, which, as of this morning, has resulted in the decline of domestic murders by 53% in 2026 alone. This is tremendous progress, yet I also experience the stark difference between the city and Cook County court system that is not transparent with the public. It's not transparent with the public, with stakeholders, nor with the City of Chicago. Data requests from commissioners submitted months ago were still outstanding for many departments, and yet experts all agree that focusing our attention to the specified priority areas is imperative to safeguarding and continuing the progress that has been made thus far to save the lives of victims and survivors. Sadly, it also became clear to me that the lack of transparency and data sharing regarding enforcements of warrants, orders of protection, and GPS are also resulting in the deaths of Chicago's first responders. The task force has been told that there are 72,000 outstanding court warrants. Almost half of orders of protections are not served, and that GPS programs may be using CPD as their enforcement mechanism when security perimeters are being breached for domestic violence cases. Due to the Cook County courts not being subject to the Freedom of Information Act and the lack of public information, I call this hearing today to begin the conversation on behalf of City Council with our partners on how we can develop a unified approach to solving the public safety crisis caused by these 3 focus areas. This hearing is an opportunity for members of the City Council to receive data and information to begin a long overdue discussion on collaboration. This hearing is not meant to deliberate state or federal legislation, nor any specific litigation on court case proceedings. I want to note that due to scheduling conflicts with another hearing today across the hall, I previously circulated the data requests and asked my colleagues in City Council to send over their questions. We gathered a list of questions that I will ask our partners today, but we have also allotted a short time frame for each department that agreed to participate so that they can attend and prepare for both meetings. Any follow-up questions can be emailed to their departments, and they have shared points of contact that I will circulate to members of this committee as well as to our colleagues in the City Council. I'd like to thank the state's attorney and the public defender for participating today, as well as the Chicago Police Department. It is unfortunate that the other Cook County stakeholders have chosen not to attend, yet their actions impact so many facets of the City of Chicago and the residents we serve. Their policies and programs have a direct impact on the safety of victims of violence, first responders, and our budget. Concerns about public safety have driven residents and businesses out of Cook County, which means higher property taxes and less resources. Everyone is impacted, yet even as elected leaders, we have a limited understanding of the court system. The City of Chicago has a violent crime dashboard, updated every morning. CPD tracks every interaction with the public. The OIG tracks every 911 call, and there are layers and layers of accountability for our first responders. Yet, some simple questions will likely remain after today, such as how many active criminal warrants and orders of protection are there, and how many have not been served? What are the plans for the GPS programs? How can we create a unified approach to public safety and protect victims and first responders? Finally, the data that I requested was sent over weeks ago and was promised by the clerk of the courts. That data I have not received as of this morning. We will continue to request data under under this task force, and I will share it with the Public Safety Committee once it's received. This will not deter our efforts. We must continue these conversations with the leaders of Cook County. Now I want to lead to my questions, and I want to start off with the State's Attorney's Office. May I, Chairman?
Yes, Alderman, but just for the record, we did make a good faith effort to invite all of the expected participants. We reached out for their offices. Those who chose not to attend, chose not to attend. However, I did hear from the Sheriff's Office this morning, and they indicated a willingness to respond in writing to any inquiries through the chair that are presented here today. Please add Alderman Riley to the attendance roll call. And also, we do have a opening statement that the public defender wishes to make, but if you want the state's attorney to go first, and then after that, we'll go to the public defender.
Great.
Okay, thank you.
Good. So I want to, yes.
Oh, I'm sorry, Alderman Taliaferro.
Just a quick point of order, and I certainly appreciate Alderwoman Tabaras's leadership on this, and I certainly support it as well. Can you name the organizations that were reached out to, and all the organizations that were reached out to and invited here today, and all of those that declined or refused to show?
So we reached out to the Cook County Sheriff's Office. They declined. We reached out to the Cook County Chief Judge's Office. They were unable to be here. They had prior commitment. We also reached out to the Cook County Circuit Court clerk. They can't be here, but they're working on getting us the data that we requested. We also reached out to the Cook County State's Attorney. They are here. They are present. We reached out to the Cook County Public Defender. They are here. They are present. And the Chicago Police Department. Seven stakeholders.
Thank you, Alderwoman, and thank you, Mr. Chairman.
Yeah, and the representatives of the Chicago Police Department are here to answer direct questions and inquiries posed to them, and that is relevant to their work, but they do not wish to make any type of statement. But they will respond to specific questions to the extent possible. So,
Good.
Alderman Taveras, proceed.
So to the State's Attorney, thank you for attending today. I want to commend the State's Attorney for being very forthcoming about attending today, and for State's Attorney Eileen O'Neill Burke's candor when talking about these issues. I want to start off with warrants. Can you give us a quick rundown on what the State's Attorney's Office role is in the issuance of a warrant, and any data that you may have on how many warrants are filed on an annual basis?
Good morning, Yvette Loizon, Chief Assistant State's Attorney for Policy and External Affairs. Thank you very much for having us here today. In response to your question, I am going to focus on warrants that are issued as a result of an individual's failure to appear in court. There are different types of warrants that the State's Attorney's Office does have interaction with. For example, a search warrant on an individual's home. But I think for purposes of today's meeting, the failure to appear warrants are what we're talking about. Is that correct? Okay. So generally, our role in the process of obtaining warrants for a failure to appear is that when we are presented with information that an individual has either failed to come to court or has failed to come to court because of some type of violation related to potentially electronic monitoring or some other issue, we generally receive that information from our external partners. And most frequently, the Cook County Office of the Chief Judge Pretrial Services Department, if we're talking about a person who's on pretrial release and is being monitored in some fashion who has not appeared, or if a person has no pretrial release conditions and they don't come to court, we have a state's attorney in the courtroom who's aware that they're not there. In that set of circumstances, it's incumbent upon us to file the correct paperwork to ask a court, to ask the judge to issue a warrant for that individual's arrest for their failure to appear. Generally, if it's a violation of pretrial conditions, we do that through a petition for sanctions. In other circumstances, it's just dependent on the facts and circumstances before us at the time. But that is our role in the process. And then if the judge chooses to issue that warrant, it's then incumbent upon the clerk's office to enter that warrant into the correct system leads so that law enforcement becomes aware that that warrant exists.
Okay. Now I want to shift to orders of protection. Can you provide a quick snapshot on what role your office plays in getting and enforcing an order of protection? For example, can you explain the difference between criminal and civil orders? And what a victim needs to get an order of protection or report a violation?
Sure. So the Cook County State's Attorney's Office has no role in assisting individuals in obtaining a civil order of protection. We do not have state's attorneys that are in those courtrooms, and we don't assist anyone in trying to obtain a civil order of protection. When it comes to a criminal order of protection, the individual that we are working with, the victim of the crime, has to have a police report. And if that person has a police report and agrees to seek the order of protection, so as prosecutors, we don't demand that the victim try to seek an order of protection. That is driven by the victim's wishes. Then we will assist them in court in obtaining an order of protection. All orders of protection are civil in nature. However, if a person has a police report and we are working towards a criminal case on that matter, that is when the state's attorney's office is in fact present in court and can step in and assist in that process. One thing I would like to note is that if an individual were to come to the domestic violence courthouse, 555 West Harrison, and provide information that would suggest that they in fact need a police report and they don't have one, there are mechanisms available in the courthouse for them to obtain a police report while they are there at that time and present. That's actually a very new development, which was the result of significant partnership between our office and the Chicago Police Department to make sure that we could facilitate that process for people who come in and are in that position.
Okay. Thank you for that. And then finally, I like to talk about electronic monitoring, which is the third focus area on this resolution. Can you give us a quick explanation of what role the state's attorney's office has in the GPS program? And if you receive any notifications on violations? And also, how do you think this program can be improved?
But prior to a person being placed on electronic monitoring, if a person is charged with a felony criminal offense that under the Pretrial Fairness Act permits us to seek detention, we will make a decision on a case-by-case basis based on the statutory guidelines and parameters as to whether or not we believe we can meet our burden of proof of demonstrating that that individual is either a danger to the community, a danger to a particular person, or a flight risk. In the event that we believe we can meet our burden of proof, we will present a petition to detain that person before the judge in first appearance court. If that petition is denied and we believe that that person is in fact a danger, we object on the record to explain to the court that we believe that we are objecting. If the judge orders that person to electronic monitoring, our objection specifically states that we object to that person who we have asserted is a danger to the community or a person being placed on electronic monitoring because electronic monitoring is insufficient to protect the public. So that's step one for us. If a person is on electronic monitoring and they commit a violation of their electronic monitoring, we are relying on the Office of Pretrial Services to provide us with information on that violation with all of the attendant details that are necessary for us to have in our possession to file a petition for sanctions in front of a judge to advise the judge that that violation has occurred. We do not direct pretrial services to alert us to that or to provide that information. It's incumbent upon them to take their own initiative to do that. Once we receive that information, it then becomes our responsibility to file that petition for sanctions if there has been a violation of electronic monitoring. And then it's incumbent upon the judge to make a decision as to how they are going to proceed. Very frequently in those situations, when we are filing a violation for an electronic monitoring issue, the offender is not present in court. So that would be a scenario where we have filed a petition for sanction for noncompliance with pretrial release conditions. If that person is not present in court at that time, we will generally ask the court to issue a warrant for that person's arrest, and then it is up to the judge to decide whether or not they're going to do that.
Well, thank you for that information. I know we have our public defender here, and I like to move on, and I know he has a public statement that he likes to read. Sharon Mitchell, can you please read your statement, if that's okay, Mr. Chairman?
We delivered
Yeah,
the
we
statement.
distributed the written statement too, but
Yeah.
please read it.
Yeah, we delivered the written statement to each of the members, so I don't think there's a need to read it in full.
May I
That's fine. Well,
proceed?
yeah, we'll waive the reading then. It
Okay.
is in the meeting record, sir, and if there's any questions.
Okay,
Proceed.
thank you. I do have a couple of questions for our public offender. Again, thank you for being here today.
Thank you.
Today, we're discussing warrants, orders of protection, and electronic monitoring. I'd like to get your opinion on how the systems are currently working and if you think there should be any changes that need to be made.
Thank you.
And if so, what would those be?
Thank you so much for the invitation here, for bringing us here today. I'm joined, Sharon Mitchell Jr., Cook County Public Defender. I'm joined by our Deputy Public Defender for Policy, Charlene Grace. There's obviously been a ton of back and forth about electronic monitoring, when it should be used, how it should be used. That is a decision that the judiciary makes, and we believe that decision should be made on a case-by-case basis using the information provided to the judge. I think one of the strong things about the Pretrial Fairness Act is that it's expanded the opportunities people have to have conversations about what should happen to a person. Before, hearings, back when I was in the courtroom, would take literally 30 seconds, 1 minute, 2 minutes. When we're talking about bond hearing, now those decisions are taken far more seriously. And I think it's been a great step forward. Our position at the Public Defender's Office has been, when somebody is put on electronic monitoring, that they should have access to the basic things that we need to keep people alive. Things like food, things like clean clothes, are things people should have if they're on electronic monitoring. Quite frankly, that has not always been the case. I have personal experience as being a public defender when people put on electronic monitoring, that they don't have the ability to leave their house, they don't have the ability to go take out the trash. And we know that that something first that's provided to anybody, even if they were incarcerated, but also it creates issues when it comes to trying to ensure that people stick with the things that keep them out of the criminal legal system. Things like school, things like receiving public benefits, things like receiving work. We want to make sure that the individuals keep those things together. I think it's also important to think about the data as well when we talk about electronic monitoring. There have been certainly instances where people have been accused of very serious offenses that are on electronic monitoring. I think oftentimes, though, we don't think about how the vast majority of people do come to court. And if we do want people, and we want to increase the amount of people that come to court, even though it's a significant majority, there are lots of things that we can do. One of the things that often happen is that when somebody doesn't come to court, there are really three kind of circumstances. Either they can't get to court, right? Many of our cases are either at 26 in California, or they're at from people far flung locations like Markham or Bridgeview or Rolling Meadows and Skokie, and people have real issues getting to court. That's a constant issue. I think the way the court is set up is also sometimes problematic. You have oftentimes people who have their first court case at 26th Street, then maybe their next court case will be at Grand and Central, and maybe their third court case could be at Skokie, and this is the same case. And oftentimes you see issues with that. I think you see sometimes issues with the structure as well. The issues of warrants for some judges happens at the beginning of the court call at 9 o'clock. If you've ever been to 26th in California, you know there's giant lines outside of 26th in California. And oftentimes people are just not getting there within moments, and therefore a warrant is issued, and that person decides maybe that they don't want to, that they don't, they may not come to court. There are things that we can do actively, especially for if the city wants to get involved budgetarily. Investing in court notification services are really strong. It's a really good technique. That's something that's been invested in other jurisdictions and that the county's invested in, and continue to work on that. I think improves court appearance rates. And also thinking about matching the investments made by the Pretrial Success Act. That was a law that was passed in the state that helped provide resources for people to get to court, to make sure they stay in work, and to make sure that they're abiding by all of the court rules. Investment in that program, added investment in that program could also improve rates.
Thank you. Thank you for that. We're being told that there are over 72,000 outstanding warrants. Half of them are criminal, 7,500 of them are for domestic related cases. With the current volume of these outstanding warrants, what do you think can be done to reduce that number to ensure clients are not missing court cases and risk further penalties?
Like I said, active steps, and this may be something the state attorney wants to take on or CPD wants to take on, but I think active steps ensuring that warrants aren't happening before they are issued there's lots of room there. There's a lot of space to ensure that those warrants aren't happening. I think it's also important to note that all warrants aren't created equal. If you have an individual a warrant for a minor offense and that warrant has existed for 5 or 10 years, that suggests that person hasn't had contact with the criminal legal system. I'm not saying that person should just never come back, but it does maybe suggest that the numbers aren't as horrifying as we might believe. But I think being active about ensuring what can we do to make sure people get to court. I know oftentimes people are frustrated. People are accused of criminal offenses. They don't want to be, they don't want to make it easier for them. But I think that with a city and a county with lots of resources, we can certainly continue to invest in ways to getting people, making sure people come to court. Whether you're talking about bus cards, whether you're talking about, thinking about how the geographic setup is court system is set up, and other endeavors.
Thank you for that. I want to move on to the Chicago Police Department, who are here with us today. We have 2 members of the Chicago Police Department. My first question is with, we've seen that one of the top arrests statistically for the Chicago Police Department is for warrants. That is the top arrest. I want to ask, can you give us a rundown on the process when a police officer encounters somebody with an outstanding warrant? And can you speak to how much time these arrests typically take so that we understand how long a police officer is off the beat dealing with an arrest as opposed to answering calls for service in the community? Can you help us walk through that process?
Sure, and thank you. Blessed morning, everybody. My name is Roderick Watson. I am the commander and executive sponsor for the Chicago Police Department Bureau of Patrol. So in essence, what happens is that once an officer encounters a respondent or subject who actually has a warrant, they will first and foremost reach out to OMC or leads to actually run that particular individual to make sure that demographics actually match, as well as to see if that warrant is active. Once they secure the respondent or subject, they actually take them into the station, transport them into the station, and then they start the processing for the arrest. Now, during that time, that can, depending on the totality of the circumstances, that can take anywhere from 30 minutes to over 3 hours. And because of a lot of paperwork that are involved with that, we have to fill out paperwork regarding stop orders and possibly case reports, as well as other reports that may take time and processing, and also going through the various remedies that are attached with that particular warrant. So that process can take over 3 hours in essence.
So we have seen instances where officers have to do overtime because they make an arrest depending on where their shift is.
That is correct, especially if an officer near the end of their watch actually encounters a subject that has a warrant that can run into over 3 hours of overtime, possibly or more.
And can you clarify that when an officer does make this arrest, they're not answering calls of service for other calls of service that are happening in the other community because they're dealing with this arrest report.
Yes, that is correct. Once an officer is in the station and processed, then that officer is no longer available to take or respond to any calls for service.
Another major issue is orders of protection, especially for individuals who have not been served. Can you walk us through short form notifications? What is that and who is responsible for serving the order of protection and updating it on leads?
Thank you. Roderick Watson, Commander of the Bureau of Patrol, Chicago Department. So a short form is actually an administrative tool in which the Police Department utilizes to actually notify or serve a subject or respondent of an unserved protective order of protection. Now, that short form, actually, that whole process, what happens is that the officer will reach out to a supervisor or sergeant. The sergeant will in turn come in and complete that short form, notifying the respondent or subject of the remedies and everything that the actual petitioner's information and who's involved. And once they go through that process of notifying that individual, then that information is taken back to the station. They will in turn make those proper notifications, and you can maybe answer that, Deputy.
Good morning, Joe Perfetti from CPD Records. So as Commander was saying, once our division is notified that a short form has been served, what we do is we will notify the issue agency that the short form has been served via leads message. In addition, we will enter a record into leads that will show the date and time that it was served and the officer that served it. And then we will also forward a copy of that short form notification to the issuing agency.
So just to clarify, a short form notification is issued when an officer encounters an individual who has an outstanding order of protection that has not been served.
Correct.
And you do the short form notification and you give that to the sheriff's office, correct?
Yes, the originating agency, which is.
For them to upload it in leads.
So a copy of, the short form notification is received by our office. And yes, it's typically emailed to us from the sergeant, and then we'll take that email and we will forward that short form notification to the sheriff's office if they were the originating agency. But we also go into leads and we update the record to show the date and time and officer that was served.
So can you just confirm, is there a required timeline for when leads must be updated? And do we know if this is being done in a timely manner so officers and victims have the most up-to-date information?
So leads mandates that whenever you receive a message, that it is acknowledged within 10 minutes. It doesn't necessarily mean they have to take action within 10 minutes, but they have to acknowledge that they received that message within 10 minutes. And then it is required that an agency take action upon the request as soon as possible.
And if a patrol officer encounters somebody who has been served and is seen to be in violation of the order, is that a mandatory arrest? And if so, how long does it typically take to process such an arrest?
Roderick Watson, Commander of the Chicago Police Department, Bureau of Patrol. Yes, that is a mandatory arrest. If that's, once that is in violation of the order of protection, an officer will enforce that arrest. And that process also, depending on the totality of the circumstances, can also take from 30 minutes to over 3 hours. Once again, they would take that particular individual into the station, ensuring that that warrant is active and that they're in violation of, and that the demographics match. And then as they're going through processing and filling out the proper paperwork and making sure that all those remedies are addressed, that process can actually go extended hours.
And I just have a couple of final things. It's my understanding that officers, police officers, are being dispatched to notifications when a respondent's GPS has breached a protected party's perimeter. Do we know how many calls CPD receives annually for these types of calls?
So that will have to get through the chair. I will have to get that information through the chair. I do not have that information with me, but pertaining to responding to GPS, the only calls for service that we actually respond to for GPS would be the Cindy Bishop Law Ordinance. And if the subject or respondent is in violation of that order, meaning that they have breached the 2,500 feet safety zone, then they're in violation of that order of protection. What happens is OMC will notify Chicago police officers to go out and investigate. And if that particular individual or subject is on scene and in violation of that, then they will enforce their arrest. The other monitors that may, GPS monitors that may actually get activated if they're in violation, that is not under our jurisdiction. That would actually fall under the county, Cook County Sheriff's Office.
Well, I like to thank CPD for their time. I want to make it clear that warrants and orders of protection are court orders. They are court orders. This means that CPD spends a significant amount of time enforcing Cook County court orders. This is something I think we as a council should consider when we're discussing response times and overtime spending, that CPD is spending a lot of man hours dealing with Cook County court violations. Mr. Chairman, I just want to say that in closing, that I like to thank you. I want to thank you for being such a strong advocate on this issue. I also like to thank the advocates and survivors who provided public comment today, Sarah Brown and your mom, Diane Brown. Thank you for joining us today. It's their strength that ignited this discussion and will bring about true reforms. I also like to thank the Cook County State's Attorney's Office and the Public Defender for joining us today and being open and transparent about the issues. I like to say that we also invited the Cook County Sheriff's Office and the Cook County Chief Judge's Office, both who are not here today and declined to send a representative. I also want to note that we also invited the Illinois State Police as well, and they're unable to be here, but we are in close communications to getting answers to our questions. Finally, we asked to have this hearing in the spirit of openness and transparency. We wanted to have an open and transparent and honest conversation in public about warrants, orders of protection, and electronic monitoring. I even reached out to the Cook County Sheriff's Office and the Chief Judge's Office, even as going so far as sending my questions in advance, but they're not here today to answer our questions. Finally, whether you're a sheriff, a judge, or an alderman, you're a public servant. And you owe it to the public to not hide information and collaborate to find solutions. We can't solve big problems without first being open about the issues. The Cook County judicial system is not subject to FOIA per state law. I think the major takeaway from this hearing is that we cannot move forward without state law changing to force the Cook County courts into the light. Thank you.
Thank you, Alderwoman. Please add Alderman Lopez